Today we will discuss the relationship between municipal law and international law. How to determine relationship between international law and municipal law. Whether municipal law and international law are both are same or they are separate. For this, there are 5 theories which explains the relationship between international law and municipal law, and also that is how the relationship between state and state law as well as the international law, which are determined under the actual practice of states. Now we'll go with that it is a theories which explains the relationship between municipal law and international law. You know that what is municipal law or state law is the domestic laws. According to that domestic laws, that is the state is governing, and international law, you already know that international law is that it is governing by, that is what now we have that is explained the sources, that is in particularly with regarding to that that is international conventions or the that is customs or laws or any other laws which are governing the international relationship between the states. Now we'll go with what are the theories. There are 5 theories. Under that monism and dualism are the basic theories, and they are the main theories in order to determine municipal law and international law. According to monism, that is the word itself says that mono means only one. In that way, that is municipal law and international law, both are not separate. They are both are the derived from the same grandorum, or the that is unified field of knowledge. They are not that is different, but they are intimately connected with one another. Both are derived from the that is science of laws or the unified field of knowledge. That is, even though both are there, it is 2 phases, but both are the 2 phases of the same phenomena. For that, there is no difference between international law and municipal law. Even in that is the main exponents of this theory, Kelsen, Dagite and Westlake. They are the opinion that is these either municipal law or international law are all that is derived from the one grand norm, or what is called as basic norm. For that is individual is the root of all laws, whether maybe domestic laws or state laws or international law, all that is all laws, that is individual is the root of all laws, whether maybe international law or municipal law, irrespective of that is in the ultimate analysis, individual is the person who represent both the laws. In that way, that is both are not separate, they are the unified field of knowledge, and they are the that is intimately connected with one another, and they are the 2 facets of the same coin. Then it was criticized that is this theory, it is difficult to prove that is both are that is derived from the same norm, because in the actual state practice, each state is that is practicing their own laws, that is domestic laws. For that is it is difficult to prove that. Second theory, what is called as dualism. In dualism, the word itself says that dual, that is municipal law and international law are separate. Both are not the same that is phenomena. Both are that is international law is separate and municipal law is separate. Here the exponents of this theory are Triple and Angelotti. They held that is municipal laws subjects are different. Municipal law, that is or state laws, origin is different from international law. That is under state law, that is the subjects of municipal law or state law are the individuals, a group of individuals are the subjects of international, that is municipal law or the that is state laws. because individual is having certain rights and duties under international law, and also that is individual is also having certain rights and duties under municipal law. For that, that is subjects of municipal law or state law are the group of individuals, or individual is the subject of municipal law. Again, that is origin of municipal law is different from the international law. What is the origin? Here, that is the will of the state is the origin of domestic laws or the municipal law. That is, whenever a state formed into a state, it has to fulfill 4 conditions. That is a permanent population, definite territory, government, and that is the capacity of a state to enter into relationship with others. In that way, that is it is the will of the state. Only after fulfilling all these elements, that state can emerge as an independent state. That is the origin according to municipal law. But according to international law, that is the subjects of international law are different. That is here subjects of international law. Again, who are subjects of international law? That is here, that is individuals and states and international organizations are the subjects of international law. In that way, that is international law, that is originally or traditionally international law is concerned only with the states relationship. For that, that is states are the subjects of international law. But modern international law said that that is not only states but also individuals and international organizations. But it is traditionally or originally it is international law is concerned with the states relationship, and that is states are bound by the international law according to the that is opinion of this Ancelotti and Triple of international law. Then that is origin. Origin here, because that is the common will of the states. Common will of the states is the origin of the international law. When a group of states, when they enter into treaty agreements, those terms and conditions of that agreement are binding on the state parties. In that way, that is international law is bound by the relationship between states. Thereby, the states are binding by the international rules. For that, that is the common will of the states are the origin of that is international law. In that way, international law and municipal law are different because the subjects are different, their origin is different. Second theory says. Then here even there that is Ancelotti and Triple held that international laws that is the customary and conventional rules those are the sources of international law. For that international laws that is different and municipal law is different and they are not same. Third one, specific adoption theory. According to this theory, that I said already that these are the 2 main theories, but other theories are that is international law cannot be directly enforced in the municipal law. For that, in order to that is incorporate international law into the municipal law, that international law is to be specifically adopted by that government or by that state's parties. For example, that is in 1976, that is Indian Constitution was amended because in 1950 it was not related with any environmental issues. But when India is signatory to the Stockholm Declaration, which was held in 1972 on the subject of that is environment pollution or protection of environment. At that time, that is India has also signed for that in order to incorporate that that is conventional laws. That is Stockholm Declaration, that is obligations. India has that is amended to the Indian Constitution 1976 under 42nd Amendment. According to that, that is Article 48A and 48A and 51A to G was incorporated under that is under Constitution. These held that is there is a duty lies both on the individual as well as the citizen as well as the state. to protect environment, including that is forest and lakes and others. Like that, what is called as that is international law cannot be directly incorporated in the municipal law or cannot be enforced in municipal law. For that, that is international. In order to incorporate international law, that should be specifically to be adopted in municipal laws. Next, transformation theory. In transformation theory, it is also held in that is Jolly George case. It also said that the Supreme Court held that is the foreign any foreign laws ought to be incorporated in municipal law. That should be go first. That is specifically to be adopted in the state constitutions. Next one theory is that transformation theory. According to this transformation theory, same type. That is, international law cannot be directly enforced in the municipal law. For that, that is, international law is to be transformed in the form of municipal law before it became an obligation with regard to the treaty obligations. Next one, delegated theory, delegation theory. Under delegation theory, that is again, international law cannot be directly incorporated in the municipal law. That is. Under each constitution of that states, that is international law it is incorporated by their constitutions. This is what is called as delegation theory. These are the 5 theories which explains the relationship between international law and municipal law. That is, we will go with 3 state practices. One is UK, USA and Indian practice. First, we will go with UK practice with regarding to customary rules of international law and treaty rules of international law. In UK, it is international law is considered as their own part of laws, and whenever they lay down any laws, that should not go against the rules of international law. It is a subject to conditions that it is the rules of international law should not go against the statutory laws of England, and once the highest court in England, that is House of Lords, if they lay down any decision, that decision is binding on all the courts in England. And with regarding to treaty rules of international law in England, it is the rules regarding to relationship between international law and municipal law is based on the relationship between executive, crown and the parliament. With regarding to certain treaties requires the consent of the crown, and in certain cases the consent of parliament is required. For example, it is negotiation and signature, it requires the consent of the crown. In case of any modification to the treaty or agreement, or any imposing any treaty rules on the treaty rules with regarding to the financial burden, it requires the consent of the parliament. In this way, that is UK practice with regarding to relationship between municipal law and international law is dealing with those customary rules as well as the treaty rules of international law. They will consider that those international laws are their own laws and part of their own laws, and not that should not go against the municipal law. If there is any conflict between municipal law and international law, it is prevailing over the municipal law and not the international law. It is a state practice with regarding to UK. Next, we'll go with USA practice. In USA practice, even USA also that is considers customary rules of international law are part of their own laws. Justice Gray in Packet Havana case, he says that is international law is a part of their own laws, our own laws, and those are that is applied and ascertained and administered in appropriate jurisdiction with regard to the rights of the parties. In Packet Habener, that is Justice Gray held that the facts of this case are that Packet and Habener both are the fishing vessels. These two fishing vessels carrying the that is a flag of Spain, because they belong to Spain. At that time there was a war was between that is Spain and America. That is in 1890. When these two vessels reached Cuba port, that Cuba was belonged to the that is American that Cuba port was a colony of the Spain. When these ships reached Cuba port, at that time the warships of America they seized those two vessels and they brought before the District Court of America. That is the District Court of America held that it is both ships are belong to the Spain, as that those are the enemy ships. For that they are to be prosecuted. The owners of these two ships, they filed an appeal before the Supreme Court of America, and American court held that these with regarding to these ships, that is the crews of these two ships, when they are working promptly and without making any harm, those should not be prosecuted, and those are to be given compensation and money, whatever the sale of that cargo, that money is to be given back to the crews. It was for that it is said that is in international law it is never gone contrary to the principles of international law. Instead of that, they are treated that those customary principles of international law are the part of their own laws, and those laws are to be administered and to be ascertained in regard to appropriate jurisdiction with regard to the rights of the parties. Next we go with what is called as treaty rules. With regard to treaty rules, in USA, it is based on the constitutional principles. That is Article 6 of the Constitution. It says that in all cases, in pursuance to the Constitution as well as international law, it is the supreme law of their land. For that, it is said that any treaty which is entered on the basis of Constitution and the international law, both are regarded as the law of the land or supreme laws. Then, with regarding to treaty rules in USA, there are two types of treaties which are considered. One is self-executing treaties and second one is non-self-executing treaties. The word self-executing treaties itself says that is those treaties which does not require any consent of the Congress or Parliament of USA. But in certain treaties which requires, that is non-self-executing treaties which cannot be executed by self. For that, such treaties requires consent of the Congress or American Parliament. In this way, USA also considered the state practice with regard to the relationship between municipal law and international law. They considered both customary rules of international law and treaty rules are not separate, but they are that is the customary practice, and they are the rules of their own part of their own rules. Their own laws. In that way, it is considered. Then Indian practice. With regard to Indian practice, again it is classified into customary rules of international law and treaty rules. These Indian practices will be considered prior to the Constitution and that is post-Constitution. Prior to Constitution came into effect. That is, India is also considered these customary rules of international law and treaty rules, and those are the part of their own laws as that of the USA or UK practice. But after Indian Constitution came into effect, under Article 51 it is provided that is the states should endeavor or to try to promote international peace and security, and to respect the international laws and treaty obligations, and that is international disputes are to be settled peacefully. Article 51. Now Article 51C, it says that Article 51 is mentioning about that is international obligations and treaty rules. This was laid down in this by Supreme Court in ADM Jabalpur versus Shukla, Jolly George Varghese versus Bank of Cochin, and Vishaka versus State of Rajasthan. In Jolly George, it is saying that two conventions of human rights, like Covenant on Civil and Political Rights and Covenant on Economic and Social Council are both even though both are the international treaties, but those are not considered as a part of municipal law. It was held that. But whenever there is a conflict arises, that is what already said, that is it is a municipal law which is prevailed over the international law. In Jolly George Varghese versus Bank of Cochin, it is also that the same thing was given by Supreme Court of India in this case. Now we'll go with again Vishaka versus State of Rajasthan. In this case, it is said that in the absence of domestic law, recourse to be given to the international laws with regarding to the sexual harassment of women at all working places. Effective measures to be taken to check the evil. That is the contents of international law and norms of international law are most significant, and the purpose is to interpret the rights which are guaranteed under the Indian Constitution with regarding to gender equality as laid down in under Article 14, and right to work with human dignity, Article 21, 19, 1G are implied under the Article 51 of the Indian Constitution. In this way, that is, it is the state practice with regarding to relationship between international and municipal law. That is, in conclusion, in this, what we already known that is in order to determine the relationship between international law and municipal law, there are 5 theories what we already discussed. That is monism, dualism, then specific adoption theory, transformation theory, and delegation theory. Apart from that, there are state practices which are also considered. That is, what is the actual practice with regarding to the determination of relationship between international law and municipal law. These are the things which are taken. And it is said that there is no big difference between international law and municipal law, but in all the state practices, international law cannot be taken as considered as against the municipal laws. But whenever there is a conflict arises between two municipal law and international law, it is the domestic law or the state law which is prevailed over the international law. This is the state practice with regarding to with relation to municipal law and international law. Today we are going to discuss the origin and development of international law. Now we'll go with what is origin, how international law was taken place, or how international law was taken its birth. For that is Oppenheim, as being a celebrated author of international law. He states that international law is a product of Christian civilization, and it was the experience of Western jurists, and it was gradually developed in 14th century onwards. And this was criticized by many jurists like Kapoor and others. They said that Oppenheim said that international is a Christian product of Christian civilization is not correct, because here in the original text of Ramayana and Mahabharata, it reveals that the sovereign states are based on the sovereign international law, and these international rules are based on the sovereign states. Even in Kautilya's Arthashastra, it's also treated that is diplomatic envoys are treated and reception were known at that time. For that, it is not purely originated from the Christian civilization, but it was contributed by many history reveals that contribution given by either Jews, Greeks, Romans, Hindus and Muslims for the international law, and it also developed according to Oppenheim said that international law is developed from 14th century onwards, and it is a Christian civilization. Because it was to be agreed, because from 14th century onwards, due to Renaissance and Reformation, international law was developed in the quick manner. In that way, we can agree with the Oppenheim's that is statement. International law is a product of Christian civilization. First, we'll go with what is the contribution given by Jews for the development of international law. First time, Jews. Ancient history had revealed that Jews had relations with other states. Whatever the treaties which are entered by the Jews, those were strictly followed by them, and they were conferred certain privileges and immunities on the diplomatic envoys. This was the contribution which is given by Jews for the development of international law. Next, we go with Greeks. Greeks, again the ancient history reveals that the philosophers like Socrates, then Aristotle and Plato, they enlightened the world with their philosophical ideas. That is, these Greeks were lived in small city-states. Their relations were governed by definite rules and principles. They have definite rules relevant to the war and peace, and also they resolve the disputes by arbitration. And that is, they know that prior declaration that is before commencement of war, prior declaration is required. This is the contribution by Greeks to the development of international law. Then Romans. Regarding the Romans, that is, the great contribution by Romans is to the astronomy and mathematics. That in that field it is significant. Then Romans were living in small city-states. They had relations with other states. They are independent and sovereign states. That sovereign states, they are given, that is independence which is given, that is supreme power which is given. That is a contribution to the international law. And with regard to war, they are classified into two types. One is just war and unjust war. Unjust war means that is an attack on the Roman territories or violation of principle, that is privileges and immunities that is conferred on the diplomatic envoy. Those are considered as just war. And treaties are again that is classified into treaty of friendship, treaty of alliance, and treaty of that is hospitality. And what are the treaty that is rules which are that is entered between the states? Those treaty rules are strictly adhered by the Romans. Next, the contribution is given to by the Hindus to development of international law. Hindus. Valmiki Ramayana, it is revealed that the relation of sovereign states was governed by certain, that is, code of conduct, and these were observed by the sovereign states. Then diplomatic agents are conferred certain privileges and immunities. Again, that is, it was also required that before commencement of war, that is, declaration is to be made, and also that is, war should not be waged before sunrise or after sunset. It is also found in the Manu Shastras, that is, killing of wounded persons and sick soldiers were prohibited. They had rules relating to the prayer of war. Then, contribution of Muslims. Muslims were contributed to the development of international law. The Muslim rulers, they had relations with other states, and they received the ambassadors and treated in the manner. Then whenever they entered into treaties, those that is they are observing in good faith. Those provisions of treaty are that is following in good faith. Again, that is main contribution of these Muslims is that they made distinction between its women and that is children. They were given more importance to those that is vulnerable class. Then again, they were also classified, that is combatants and non-combatants during the war. Combatants are those the persons who are that is waging war, that is soldiers and others, and non-combatants means those are the persons like barbers or cooks, or those comes under the that is non-combatants. In this way, that is these are given, it is contribution for the development of international law. In that way, that is, it is to be agreed that is international law is not purely that is the product of Christian civilization, but international law was known even before that, before this Christian civilization. Means that is in Indian history reveals that is Hanumanta or Anjaneya was sent to Lanka as a messenger. Like this, it is international law was developed. Next, international law was developed in 15th and 16th century. That is a number of treaty agreements which are entered between the states. These treaty obligations were considered as those are binding in the state relationship. First treaty, what is called as Treaty of Westphalia, 1648. This was the first landmark treaty in Europe, which ended 30 years of war of religion. And they in Europe, they started to accept the new political orders, and it was the beginning of those new political orders. And they realized that no state can live alone, and they required that is unity between the states. This was the Treaty of Westphalia, 1648, which was a landmark treaty. Then Grotius period. That is Grotius, who is one of the Dutch citizen, national. He was considered as a father of modern international law because he has published two treatises. One is Mare Liberum, it is called as Freedom of Seas in 1609, and De Jure Belli Ac Pacis in 1625. De Jure Belli Ac Pacis means it is war on peace. On these two treatises, he has strongly argued that the freedom of seas and the conditions which were prevailed in Europe. At the same time, in Europe, there were number of independent states, and they were having common interests. These were supplied by Hugo Grotius in the manner of legal basis. For that, he was called as father of modern international law. Again, that is, he has also revealed that natural law was the basis of determining the conduct of states. Natural law, that is, what is natural law? It is developed. According to natural law, that is prior to the existence of states, man used to live in natural state. At that time, he is enjoying all the fundamental rights, like right to equality, right to self-preservation and others. For that is apart from this, that is various other jurists like Ayala, Belli, and that is Balguna. Then also that is published various books, and it was called as a battle of books, which are given which are given contribution in the form of Renaissance and Reformation with regard to the prevailing conditions in Europe. Next, it is 18th century. In 18th century, that is, there are certain schools are established with regard to school of naturalist. According to natural theory, According to this theory, that is says that law is a dictate of reason. Man has to live according to his thoughts or dictate of his reason or faculties. For that, then that is a positivist views. Positivist view is based on there is a will of states. That is, the international law is based on the will of the states or common will of the states. When they enter into agreement, those treaty provisions are binding on them, and that is the supreme law with regarding to positivist is that pacta sunt servanda, that is the treaties entered by the states are to be respected and to be followed in good faith. Next to Grotians. Again, Grotians also developed that is international law in the manner that is before this international law as is a product of Christian civilization, and that is it was developed. It was based on the religion and secularism in 18th century. Then 19th century, the development of international law in 19th century. Now we'll go with, among them, Congress of Vienna 1815. Again, it was the landmark treaty agreement which was entered by the European nations. That is, this conference laid down many rules regarding to international treaties. For example, classification of diplomatic envoy into 3 classifications, or that is international class, that is with regarding to international rivers and those. Then Declaration of Paris 1856. In this that is lawmaking treaties, these laid down certain lawmaking treaties that is they laid down rules relating to naval warfare and attack on undefended people, that is during the naval warfare, were prohibited. Then enemy ships during the war, enemy ships are to be sunk or otherwise to be destroyed. Before doing sunk or to be destroyed, precautions to be taken with regard to the that is crew of the ship, because that is the humanitarian laws which are based on that. They are, and to this extent they entered into treaty agreements. Next to Geneva Convention of 1864. In this Geneva Convention, rules laid down regarding to wounded and sick soldiers, sick members of the armed forces relating to land war were prohibited. Killing of wounded soldiers are prohibited. With regarding to this Geneva Convention 1864. Then Hague Convention. In this Hague Convention 1909 and 1907. Hague Convention 1899 and 1907. Hague Convention. In this Hague Convention, that is the rules relating to international disputes are to be settled through peaceful means. These peaceful means either may be arbitration, mediation, judicial settlement and others. Again, in this treaty, that is they laid down with rules regarding to naval and land warfare. Efforts are also made to declare the limits of armaments and ultimately to disarmament. Then the rights and duties of the neutral states were also that is concluded under this treaty. The great that is contribution of this Hague Convention of 1899 and 1907 is the establishment of permanent court of arbitration. It was the great contribution towards the development of international law. Then what is called as League of Nations, contribution with regard to League of Nations. This League of Nations was established in 1919 in Versailles. This League of Nations, in that the states which are entered into agreement or treaty agreement, they laid down for the first time, that is imposed certain restrictions on the nation's right not to resort war at their will, not to go for war at their own will. That is, before resort to war, before going to war, they have to settle that disputes in a peaceful manner, like arbitration or negotiation or judicial settlement, intervention, inquiry, like that. Even if it is failed, then the state parties who are entered into this agreement not to go for war until the expiry of 3 months. This was the treaty which was laid down. Again, the great contribution of this League of Nations for the development of international law is the establishment of what is called as PCIG. This establishment of Permanent Court of International Justice. It is the predecessor of ICJ. It is International Court of Justice. Next to Treaty of Locarno. Here, this Treaty of Locarno. Some states like France, Brazil, Germany, and Italy, they entered into agreement that they laid down that is they are under obligation not to use force against each other in settlement of boundary disputes. This was the contribution which was laid down under Article 2, Subclass 4 to Para 4 of the United Charter. This was the main contribution with regard to this. It is called as Treaty of Locarno. It is Article 2.4 of United Nations. What it says that? It says that is prohibition of use of threat or force against any states, either political independence of any state or territorial integrity of any state. Otherwise, the members of United States not to use any use of force or threat against each other. This is the principle which was laid down under Charter of United Nations. This was the main treaty just given, because it was given in 1925. This became the principle which was incorporated under the Charter of United Nations. And like that, it is the contribution given by different treaties. Next, under this again, then what is called as Pact of Paris. It is the next treaty agreement is the Pact of Paris or Kellogg Bride. In this treaty, it is the parties who are agreed to renounce war as an instrument of national policy for settlement of international disputes. That is, according to this treaty, the states which have entered, they agreed that not to use that is war as an instrument of their national policy. This was a contribution given by, that is, Pact of Paris, or what is called as Kellogg Pact 1928. Next to, it is Geneva Convention on 1929. Next treaty is the Geneva Convention 1929. In this treaty, it is the parties agreed that the rules laid down regarding prisoners of war are to be prisoners of war are to be treated as a humanitarian, and they should not be used as in a cruelty to these prisoners like mutilation and other cruelty are prohibited. And again, collective penalties were also that is prohibited, and captives of these wounded soldiers are also that is what is called as prohibited under this convention. This is what is called as Geneva Convention 1929. Then the Second World War. Next is the Second World War. This Second World during the Second World War, that is whatever the rules are the rules which were laid down by these different treaties, or that is Second World War. These rules of this treaty are utterly that is violated by during the time of World War II, and it gives rise to the sowing of seeds for the future organization. That is what is that organization which was developed, which was established in 1945. It is what is called as United Nations Organization. Next treaty is the United Nations Organization, which was established in 1945, October 24th. This United Nations Charter lays down certain rules, what is called as principles and purposes. According to this, that is the main purpose of this United Nations Organization. It laid down that maintenance of peace and order, that is maintenance of international peace and security is to be established, is to be maintained, and in order to that extent, measures are to be taken in order to prevent the suppression or act of aggression to the international peace and security. And also it also laid down that is what is called as principles under Article 2 of the Charter. That is the most important, what I already said, that is Article 2 subclass 4, the prohibition of use of force or threat to the political independence of the state or territorial integrity of any state. And Article 2 subclass 7 deals with the non-intervention in the domestic affairs of any member state. Even the members of United Nations are not having any right to intervene in the domestic affairs of any state. This was the principle which was laid down again by ICJ in Nicaragua's case. It's what is called as military and paramilitary activities in and against Nicaragua. This is that is what is called as origin and development of international law. Thank you.